If I catch the doctor in a lie during his deposition, can I use that lie to prevent the doctor and his attorney from trying to get your case thrown out later on? You want to know the answer? Come join me for a walk downtown in downtown Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is absolutely yes. I can use that lie. If I catch the doctor in a lie, you know what's going to happen? I'm not going to share that information with the doctor. I'm not going to let him and his attorney know that I caught him in a significant lie. At least not yet. Once we have completed discovery, now we take your case and we put it on the trial calendar. The defense will often at that point try and get your case thrown out before we ever get to trial. Now, what does that mean? It means the defense will make a motion for summary judgment. Now, what's a motion? A motion is a formal written request for the court to take action. What's summary judgment? Summary judgment is an attempt to go ahead and get the judge to say, look, there is no possible way that we would ever win at trial, and there's no facts for the jury to consider. Instead, it's simply a question of law for the judge to recognize, and therefore, this case should be dismissed before ever getting to trial. So now let's get back to the question I raised at the beginning of this video. If I catch the defendant doctor, the doctor whom you have sued, in a lie, can I use that information to prevent your case from being thrown out? And the answer is yes. But, there's a but here. But, the lie that I catch him in can't be something minor. It can't be something that he simply forgot that's contradicted in the hospital chart. That's not how it works. The lie that I catch him in has to be significant. It has to be material to the issues in the case. It has to be material to the issues that we are claiming occurred in your case. So don't think for a second that just because a doctor may have misspoke, that that's sufficient to prevent your case from being thrown out. No, that's not how it works. Once the defense asks the court to go ahead and throw your case out, we have to show that there is proof to establish what we call significant material questions of fact in order to prevent your case from being thrown out. Now, what does this all mean? Okay, so let's go back for a second. A motion for summary judgment is a request to the judge to say, listen, there are no questions of fact to be decided. Questions of fact, by the way, are decided by a jury. If there are questions of fact, then the judge is going to turn around and say, hey, wait a second, I am not the trier of fact. You will have to go to trial, and a jury will ultimately have to decide who's more likely right than wrong. The defense turns around and says, listen, here's all the facts. There's no possible dispute here. There are no issues of fact. We have medical experts to support that nothing was done wrong. And now, our goal when we oppose this request is to establish that there are significant material issues of fact. And you should know something else. A motion for summary judgment is similar to having a trial, except it's all done on paper, meaning that there's no outward testimony, there's nothing that happens in court. This is all done on paper. And it takes a tremendous amount of time to prepare these documents by the defense, and likewise, it takes a tremendous amount of time and effort and energy and resources to go ahead and oppose this type of request. But keep in mind, it's almost the same as if we are going to trial, except this is happening on paper. So now, our goal is to establish and to show the court that yes, there are significant issues of fact. And how do we do that? We do that using our medical experts. Our medical experts have to go through and scour the hospital record and the deposition testimony and other documents to establish that there are significant questions of fact. Where one expert turns around and says, look, doing X, Y, and Z represents a departure from the standard of care. And now the defense says, no, it doesn't. That is a significant question of fact because that's one of the key claims in our case. We are claiming that the doctor or hospital staff violated the basic standards of medical care as to certain things that occurred. The defense turns around and says, no, that's not true. Nothing was done wrong. So now you have competing medical experts. And the court is not there to decide who is right and who is wrong. Instead, during a motion for summary judgment, the court is there to decide only if there are questions of material fact, and if there are, the defense's request is going to be denied. If there are no questions of fact, then the court absolutely will go ahead and dismiss your case. But now going back again to the question that I raised at the beginning of this video, if I catch a doctor in a lie, can I now use that to establish that there are significant material questions of fact to show that the defense should not be allowed to dismiss this case before we ever get to trial? And the answer is yes. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. Every once in a while, we get a chance to come across a doctor or a witness who testifies falsely for whatever reason, and now we catch them in a lie. And now, using that before we ever get to trial, yes, we can use it when they turn around and try and get your case dismissed before we ever get to that point, the trial. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.